My son decided he had enough of Michigan January and went back to Bocas del Toro. That would be a good place to be right now. Good morning, Raymond. I met your sister at the Toyota dealership on Monday. I was gonna say good morning to her, so good morning to people from Colon. She was very nice. Good morning, Mr. Bland. I'm gonna change your name.
Oh,
Would you
yeah.
like to be called owner?
I got a new computer, and for some reason, it refers to me as owner.
I'm sorry, Dave. I'm afraid I can't do that.
Well, that's because you're the owner of the new computer. We'll
Yeah,
change Howard to Howard Bush. Good morning, Howard.
Good morning.
Is Mr. Cap there with you?
Yes, he is, and his wife is also here. They're right
All
behind.
right, very good. He's gonna have to remove his hat. I had another person in here, but I think we've got everybody we need. This case has certainly got some wrinkles in it. So let me call it.
Did you get my answer?
I did. It was very helpful.
I
All
got
right,
it too.
this is file number 242393 LT Clifton Harden versus Casey James Cap and other occupants at 6 Road, White Pigeon. And there's Valerie back there. Anyway, this is filed, I believe, as a termination of tenancy action. But as I said, there's multiple issues with this. We'll see if we can parse them out. But as defendants in a landlord tenant proceeding, even though you are represented by counsel, Mr. Howard Bush, the law requires that I advise you of certain things regarding a landlord tenant case. First of all, you have a right to hire an attorney. You've already done that, so we'll skip that. You have a right to a trial by a jury or by the court. The plaintiff, Mr. Clifton Harden, is in the office with his lawyer, Mr. Victor Bland. The defendant, Mr. Cap, and his wife are in the office with Mr. Bush. The defendants were served with a demand for non-payment of rent on November 11th, 2024. But it says you owe property tax. And then what they actually filed was a termination of tenancy action on December 17th. They did not file a copy of a lease or any other agreement with the matter. So the defendant retained Mr. Bush, and Mr. Bush filed an answer raising a number of issues. He did attach a purchase agreement.
And there is a later one also. I did not have it at the time.
All right, well, this one is entitled Rent to Own Contract. It's dated November 20th of 2018. And the parties are DC Investments, Inc., not Clifton Harden, and the defendants. And this is not just a rental, it's a rent with option to purchase that was supposed to take 108 payments. I can't tell how many have been made. It's also got unenforceable clauses in it. It's got a 10% late fee, which is not allowable. It's got other things in it that don't comply with the Landlord-Tenant Relationship Act. If renter fails to make a payment within 60 days of the due date, renter agrees that the owner shall have the right to enter renter's property for the purpose of taking possession of the rented property. That's not a permissible clause in a rental contract. Further, the the contract says the renter has 60 days to make the payment. Plaintiff gave him a 30-day notice to quit. They also contend that the property taxes are not paid. And Mr. Bush contends that they are paid. So there's multiple problems. The first problem, Mr. Bush and Mr. Bland, is it doesn't even look like we have the correct plaintiff. The correct plaintiff should be DC Investments, Inc. Mr. Bland, what's your response to that?
Well, there's a subsequent contract. And I believe, I can't tell the date from it, but in that contract, and Mr. Bush sent this one to me, I think yesterday by
I
email.
just received it.
Yeah, and
found
it is essentially the contract Your Honor is looking at, except it does change the owner to Clifton Harder, and they've initialed it.
Okay.
And it was notarized, though. I think I can tell you the notarization date. June 19th, 2023, it was notarized by Cliff Harder, Amy Watson, and Casey Cass. And I have
Well,
that.
obviously that should have been closed with the summons and complaint. So, all right, let's assume that there is some sort of rental agreement. Then this isn't a termination of tenancy case. It's a demand for non-payment of rent case. According to the contract, they have 60 days to cure it. And Mr. Bush contends that it isn't in arrears anyway, that the property taxes are not delinquent.
Well, Your Honor, this new contract, and again, I can probably screen share it if I'm smart enough, which I may not be, but it says 30 days, I believe. Renters agree that if the rent is more than 5 days late, this agreement is broken and will automatically revert to month rental agreement and may be terminated at any time thereafter with a 30-day written notice from owners.
Okay. So there's apparently some sort of a contract that the plaintiff didn't even have. Excuse me, just a minute. No matter what the period is, it still appears to be a non-payment of rent case rather than a termination of tenancy case. Well, Howard, let's hear from you and we'll see what your perspective is.
Your Honor, please, my clients have the funds to pay. There's rent due November, December, and January. We have the funds ready and available. The plaintiff had demanded payments in cash. They said, fine, where do we pay him? And he said he'd come and get them or something. They have the money. They don't know how to get it to him. We would ask the court, could we pay it through the court?
Well, as you know, once a termination of tenancy case is filed, the landlord can't accept rent. But I don't think this is properly a termination of tenancy case. I think it's a non-payment of rent case.
I think it is too.
And, well, in addition, there were 108 payments made or to be made, and it looks like dozens and dozens of payments would be made. So the plaintiff just wants them to leave. I keep all the money. I get my house back. And you have to move. So I don't think it's a termination of tenancy case. I think it's a non-payment of rent case. And the fundamental issue, well, it's got a bunch of problems. In the non-payment of rent notice that they got, it said failure to pay property taxes. If your information is correct, it doesn't look like the property taxes are delinquent.
The 24's been paid also.
24, not yet, no.
So the 23 and 24 taxes have been paid?
The 24 haven't been paid, but they aren't due yet.
Okay.
Yet. They will be paid.
All right, and you've got $403 for November, December, and January, and are you ready and willing to pay it?
Wait a minute. I can't understand. I think Howard's talking and you're talking, Judge. I can't understand both of
sorry.
you. I don't know if Howard's talking to us or his clients.
All right. So first of all, Victor, my take that this is filed as a termination of tenancy action. Your client didn't file a contract or a lease when there actually is one in effect, which gives them a right to pay the rent and keep the property. There's a list of payments. I didn't count them, but it looks like hundreds of payments have been made since 2018 towards the purchase price of $35,000. Mr. Bush, does your client have an estimate as how much they've actually paid toward the purchase of this property?
We had it
He's looking, I believe.
on this calendar. 2025, the next one. Right here on the calendar.
Up until November of
All those up there,
2024,
Yeah.
15,250.
This one?
but it was supposed to be 12,000 because it got switched.
60 days.
They
So how much have they paid?
The balance. I'm
Yeah.
sorry.
somewhere around
We've paid more than half.
More than half. It was only like 12,000 owed.
12,000 is presently owed.
All right. Mr. Bland, what's your position here?
Well, you know, there was some difficulty, I think, on how to file. The taxes obviously were not paid at the time, and I don't believe the rent was current, but I could be in error on that. My client also, I mean, his position is he wants the property back because he also believes that they've made, I'll say, alterations to the property that may be diminishing its value. There is a clause in a contract that says renters shall maintain the property at renter's expense in clean, good working order. Mr. Bush did send some pictures where it looks like they're doing some kind of work inside. My client's got photographs of outside stuff that does not look, to me anyway, if it's still that condition, that it's code worthy. So, yeah, you know, if you want to take testimony from him as to what he thinks in terms of why there's been.
Well, there's a
alterations
couple
to the process.
problems. First of all, the case needs to be adjourned for at least 7 days. Every landlord tenant case gets a 7-day adjournment. Secondly, he can't do what he wants to do. This rent to own contract stinks. It's full of unenforceable clauses. I don't even have it. You didn't file a copy of it with it. He wants them to leave, give him the house. He keeps their 12,000, 18,000. Well, if they paid 23,000, he keeps all their money and gets the house back and they leave. He didn't even file a copy of the contract. You didn't even have a copy of the contract and Mr. Bush provided it with you. So they have a lease that is a month-to-month lease, and you haven't properly filed a termination of tenancy. For one thing, you ignored the fact that there was a lease. You filed a termination of tenancy, or you filed a non-payment of rent notice saying that the taxes had not been paid, but apparently they were paid either before that or after that. So that doesn't even obtain. So the question is the taxes are not delinquent and the rent would not be delinquent if the plaintiff would accept the rent. But you filed a termination of tenancy action improperly. And they're ready, willing, and able to pay November, December, and January's rent. and continue under this rent-to-own contract. So do we agree that that's what is in arrears?
I'll have to ask Mr. Harden, what is in arrears right now? You need to speak up.
The last three, October, November, January, and they didn't pay the taxes till the 27th of November after we'd filed this.
No, he filed in December. He filed in December after they'd already paid it.
All right, so the defendant says it's November, December, and January. The plaintiff alleges that it's October, November, December, and January.
You have a receipt for October.
So we'll have to determine whether October was paid.
Not within
That's not exactly.
the-
Text message.
Oh, text message, yeah.
Yeah, we have a text message, but that's not an actual.
Well, this BS about paying the rent in cash, that's got a bad smell to it.
To the bank.
No receipts are given. They're paying this stuff in cash. I don't like it. I don't like much of it. My first inclination was just to dismiss the entire thing. Because the rent-to-own contract I have has a different owner. However, apparently there's another contract that has not been filed with the court, which may give your client some standing to address this. But
What I'd
Go
like,
ahead.
Your Honor, perhaps, I don't mean to cut you off, and if I'm being rude, forgive me. What I'd like to do is adjourn it out and I'll amend the pleadings. And then we'll see where we're at. I'll file it all as a termination.
and what's the basis for the termination?
The condition of the property, the alterations that are being made.
Now it's
That's really
that.
what upsets my client the most. And I realize that they've got a different view of that, but at this point, I do believe that there's well, the things that are the photographs show to me is a diminution of the value of the property. So I realize I'm not asking them to accept it or you to accept it at this point, but I am willing to put my client up and with the photographs, which I'll send to Mr. Bush, and we can hash that out. Court may take a look at the photographs and say, well, I don't feel that way. I respect that, but that's really the crux of this. So I'd be happy to amend the pleadings.
All right. And this is not a rental contract. It's a rent-to-own contract, which I don't even have before me, or the previous one. So presumably, when this is completed, the defendants would be the owners of the property. And it isn't clear what they're allowed to do. They're paying the payments, they're paying the taxes. The defendant is paying the taxes, the plaintiff is not. So it's clear the plaintiff intends to transfer ownership of this property at some point. 108 payments should be over with by now. So that's a little more than, well, how many is that? I don't know. We'll find out. And so according to him, they're not allowed to do any renovation of the property until they own it free and clear. That isn't clear. renters shall maintain their property at renter's expense in good, clean, and working order. That means if the furnace breaks, the defendant is responsible for it. If it needs a roof, the defendant is responsible for it. So the defendant is making some alterations to the property that the plaintiff doesn't like, but they're more than 50% through with the purchase of the property. So, all right. I'm debating whether to just dismiss the whole thing and have them start over again, or allow you to amend it. So I will allow plaintiff to amend the complaint for a termination of tenancy claim. I'm going to be gone for a bit in February.
I'm gone the last couple days of February, first week of March. I know that.
All right, how about if we continue this to Friday, February 21st at 11?
I'm good.
I'm okay.
All right, well, I'm trying to look at my time here. Today is the 24th, so 7.
Your Honor,
That's
please,
28 days, yes?
could I make a suggestion that you make this in person so we can
Yes. All right.
provide exhibit?
I'm good with that.
Plaintiff has 14 days to file amended complaint. Defendant has 14 days to answer. I'm going to do an escrow order. Defendants shall pay $403 per month. Their version is more credible than his, that they owe November, December, January's rent. They shall also pay February. Well, actually, I can only do an escrow order currently. I can't go backwards.
We will.
So an escrow order
We will
shall start.
volunteer to pay the back months too.
All right.
Can we also include the taxes I think will be due in February?
Well, I don't want to pay the
Couldn't we pay
taxes
the
into
taxes
escrow.
directly to the treasurer?
Yeah. Well, I don't want to pay the taxes into escrow. That doesn't help the delinquency, so we'll have to address that.
Okay.
But
I agree with
rent-
Mr. Bush. I'm okay with an order to pay it to the taxing authority.
Yeah, and then your client terminates their tenancy and gets the benefit of them having paid the next year's taxes, but we'll see. November, December, January, and February. But I'm not sure what the due date of those taxes is.
I believe mid-February.
Yeah, usually around Valentine's Day, I
It is on
think.
Valentine's Day.
You got a tax?
$641.61.
All right, well, I'll leave it to you, Mr. Bush. You may have the best advice maybe for your clients to pay the taxes. I'm gonna block out the whole hour from 11 to 12 and more time if we need it for that day live. Your client, frankly, Mr. Bland, is not in that great of a position based on the pleadings that are filed here. And I don't like paying rent in cash. But I guess it's not illegal, but there are reasons why they pay it in cash because they don't want to.
Well, Your Honor, he issues a receipt from what he's telling me, so. I mean,
Yeah,
I take cash payments and issue receipts. So,
okay, well, we'll address that at some point. All right. We'll block out at least an hour on February 21st at 11, live, no Zoom. Plaintiff has 14 days to file an amended complaint regarding termination of tenancy. The defendants will pay escrow. I'll just have them pay all of it. The law would really only allow me to do it from today forward, but we'll get all the escrow money paid, which will show good faith certainly on the parts of the defendants as well. So when I see a proper, yeah, it was filed as a non-payment of rent. My inclination was just dismiss the whole thing. It was poorly pled. There's no copy of the contract. They get a notice to non-payment of rent, then they get a termination of tenancy, ignoring the fact that there's some sort of contract in place, but we'll stay on the horse we're on with this file number. There are two attorneys involved that can help perhaps get us where we need to go. So we'll just allow it to be amended and continue on that date. Does anybody have anything else to add?
No, Your Honor.
All right, thank you. You're good to go.
Thank
All right.
you.
Thank you, Your Honor.
Well, Meg, that was an interesting case that shows the benefit of having competent counsel as a defendant.
Always nice to see my colleagues on the right side of,
Well, we don't know. We'll sort it out. I don't know who's right or wrong here, but
I just mean representing defendants.
yes, that's your jam.